Good morning, everybody. I see at least two faces of people who've appeared in my court already. So, young lawyers, the biggest thing that I can stress is to be prepared for not only what you think is going to happen, but all of the eventualities that could happen, because your process is going to get derailed by your opponent walking in and filing a last minute motion to continue, or a motion to quash or delay or something. When I started practicing, I had the luxury of following one of the senior attorneys of my firm around like a little duckling. And it was my job to have a piece of paper in her hand to use with a witness before she knew she needed it. And so it involved a lot of working with her in planning. And I learned really early on that part of that planning that made her really successful and then helped me in my process was to put my clients and my witnesses through their examination before you got started. We would also regularly, I'd take clients to court so that they could watch proceedings. And I would explain the process so that they would get more comfortable, because your clients will not be horribly sophisticated business people. They will not understand what's going on. We speak a completely foreign language to them and I struggle with this really badly. My wife works for Justice Lee, and she says that Justice Lee's efforts to write her opinions for a 7th or 8th grade level reader so that the litigants in her court can understand what it is that her opinion means, because it affects them, and she's writing for them, not for the lawyers. She could write a law review article if she wanted to, but that doesn't help them get the gist of why this happens or how it's explained. So in preparation, I usually think of a couple things. One is, if you remember your trial practice, they tell you to tell the story of your case. Prepare a theme. And that's great because, in my court, the theme's pretty easy. It's a temporary custody hearing, it's a temporary support hearing, it's an order of protection, it's a contempt case, or if it's a divorce, you've got all of those things to get through at various points. But the preparation is to pick those facts and the witnesses that you're going to use that are consistent with your themes, and to narrow your questions and narrow your witnesses so that you're consistent with your themes throughout. Nothing will derail your case faster than telling me, this case is temporary support. It's about need and ability to pay. And then we get off on some tangent involving business valuation, because the tax returns, you say he's running money through the business. I needed to know that theme beforehand so that I was ready to look at it. I could turn this around. I'm sitting in my office. I have next week's files on my desk. I tend to do like I did in law school, which is read a week or two ahead. And then before the cases come up, I go back through them again for the finer details. And what that allows me to do is I can look at the big pictures of a file, know what I'm going to expect. And then candidly, people tend to file things at the last minute that change the questions. There's some stipulations. There may be another motion or whatever else. But the day or two before, I'm going back through that file with a fine tooth comb to make sure I understand the issues, generally have an outline of what proof those issues are going to require. Some idea if there has been discovery or previous discussion of witnesses, who those people are going to be. Is there an expert? If so, are they on parental fitness, mental health issues of one of the parties or the child, or is it an alienation issue? So I'll be looking at those things to do. And it's the reverse of that you guys are going to be doing and trying to figure out what you are. I am a big fan and always have been of writing out my questions in advance. When I say prep your witnesses, I mean, we go through the exact questions I'm going to be asking, often with an explanation of why it matters. Never once did I tell a client, that's not the way you should answer it. Or, you can't say that, or we have to change your answer. it was always their words and always their way of answering it, but they needed to know why it was important and where it fit in the case so that they could understand it and help me better in getting the case prepped. Read the judge's local rules, whether they're mine or juvenile courts or circuit courts or chancery courts. They are going to be a potential help to you when you have an attorney who is not following the local rules. And if any of you ever end up practicing in federal court, you can lose your case before you even get off the ground by not doing it the way they want you to have it done. I fortunately did not do a whole lot of practice until 2015 in federal court when I changed, I guess 2014, when I changed firms to Lewis Thomason. But my wife practiced in federal court most of her career, and it was amazing to watch her, as a defense attorney, win motions on failures to meet deadlines, keep scheduling orders, those sorts of things. So have a system in your office of a calendar with reminders about potential deadlines, have ways that you make sure you do things. One of those things I do, and that will help me if you will do it. Miss King, my assistant, emails people 3 or 4 weeks in advance generally. What's the odds of trial going in your case? I don't need, absolute 100% yes or no. I just give her a ballpark. And the reason is if you're at 75%, and then I will tell somebody I can't put another case behind you. If you tell me you're at 20%, I can tell somebody there's a 20% chance they're trying their case. You got an 80% I'll be available that day. And I'm setting 3 or 4 cases. So I need to know for all those cases behind you, as well as, the one the day before may roll over, or the one before may go over. You may want to go over into the next day. It helps me get in touch with all those people. And I read my calendar. It's one of my wife wants to take my Apple iPhone away because, we'll be sitting there and I'm like, what am I doing 3 weeks from now? And I can pretty much tell you the trial calendar and who's there. In fact, I was at a meeting last night and saw Dino Cole, and I said, hey, are you in Valone trying that case? Because it's not even until like the second week of March. What are you bothering me about? Well, that's not that far off from here, Dino. So I'm just trying to figure out what I'm doing that day. But that's where I come from. The article, without anything from Andrew Hale's future presentation, get to know your court clerks. If you have, I know they're not lawyers, but if I could tell you the number of times that young lawyers, my clerks have said, hey, this isn't going to work. And the young lawyer has said, I'm a lawyer and you're not, your job is to file it. Of course, they do, and they bring it to me and I say, I can't sign that TRO. It doesn't say this is the first request for injunctive relief. It doesn't have a cost bond. You forgot your child support worksheet on your parenting plan. They really will help you. And you can get a great relationship. Gene Cassidy used to be a clerk up in Chancery Court years ago. And one evening on Christmas Eve, as I'm working at 3 o'clock in the afternoon and had a chancellor, and I can't remember, it must have been John Weaver, I can't imagine it wasn't, sign a TRO for me, and I'm getting Gene to make copies of it, and I'm talking about going out and meeting my client. She looked down at the address and said, oh, this lady's in Halls, Greg. Tell her to meet me here and I'll serve that and you can go home to your family. It's Christmas Eve. And that's just the way the court, they will be your friend. They will do things like that for you. They will bend over backwards to save you from yourself if you can make friends with them. And really, that would be it. I'd be more interested in hearing what questions you folks have. So I'm going to be quiet, let Robin add anything that I haven't covered, which is probably a lot, and then look forward to your questions. Thank you.
Hello, everyone. I'm Robin Gunn. I'm a Knox County Juvenile Court Magistrate. Everything that Greg says is true. In practice in general, we have a really unique practice area in the Knox County Juvenile Court because sometimes you meet your client for the first time 10 minutes before you walk into the courtroom. we have not only a clerk's office, but we also have an intake office. It drives most people with a law license crazy to go into the intake office with a petition to file, to be asked questions by someone who isn't a lawyer, to tell them whether or not it's okay to file their petition. The reason that we have an intake office is actually by design. The juvenile court rules require that every juvenile court have an intake officer. They're actually court employees. They're not employees of the clerk's office. It is their responsibility to help anyone who is not the Department of Children's Services to file a petition, which even means an attorney. I hear attorneys complain a lot of, oh, this person in the clerk's office was trying to tell me I didn't have jurisdiction and I don't know who they think they are. Welcome, they are our intake officers of the juvenile court that we are required to have in place to help assist those in filing a petition. Part of their responsibility is also to read every petition and to make a report of harm to the Department of Children's Services of anything that, if true, would be child abuse or neglect. So they have to read your petition. If you take it to the clerk's office without taking it to intake, it is going to go back to the intake office to be screened to make sure that any reports of harm are made to the Department of Children's Services. It's also where all of our petitions go into our computer system, because we deal with a lot of emergencies here. We're a juvenile court, and most of what we do is deal with child abuse and neglect. We make orders about people who've never met us and who haven't entered the doors. Taking petitions to the intake office is incredibly important. It's how they enter our system, so that when Jane Smith goes to pick her kids up from school and her kids aren't there and she contacts the juvenile court, then someone can look up the petition, look up who she is, and point her to a person who can explain and read to her the petition that led to the emergency order and help her understand what is going on. So our intake office is what routes our petitions through the building. We have a clerk's office, but we also have juvenile court employees that are case managers. That it's almost like social workers that are assigned to each case. So they have people who help make sure that children are appointed guardian ad litem, that parents are offered the opportunity to fill out an affidavit to see whether or not an attorney can be appointed to represent them. There are a whole lot of moving parts. The people who are managing the case files here, we call them court case managers. They are almost like a liaison between the judge and the file. The most important takeaway from that is you're going to have to go through our intake office, and when you start a petition, and it's a very necessary part of the process. It also is how emergency petitions get the attention that they need, instead of just going into a file and or creating a file, is to make sure that they are expedited appropriately. As far as the difference between good and great with attorneys, punctuality, it means a lot. Like being at court on time will change your practice. Being able to be where you are on the docket, not overbooking yourself. As it happens to everyone, that sometimes you are already on the docket somewhere and somebody brings you a big pile of money because they need you to join them in court tomorrow. And you know what you do? You take the money and then you show up at the appropriate place early, let everyone know that you have a schedule conflict, that you help me out because I'm also double booked. I'm like, whoa, what are you doing here? Go to criminal court first and then go to juvenile court. Learn how to manage the fact that every now and then you're going to be booked. You're going to be scheduled to appear in two places at the same time. Learn where to go first. It's probably not juvenile court. But Judge McMillan knows that he gets people first, and he's right. Go down.
Okay, even when I try to tell them not to send Adam Monsieur to me, let him finish down there, they still sent him to me.
Yes,
and I appreciate that, but it was not necessary.
Yes, but go there first, and then let us know. Let other attorneys on your case know. Let people know when this happens, because other attorneys may have to plan accordingly. They may say, wow, then I need to go and handle this before I come over there, or I'm going to tell them, I'm going to let someone know, so that people with children aren't waiting in the lobby. We have children that wait in our lobby. I try to prioritize cases that have toddlers on them first because it's hard. Court is hard for toddlers. But if you're in foster care, you have to come see us. So I think that it is incredibly important to be prepared to present evidence at your hearings. And in juvenile court, that means printing your exhibits and having a sufficient number of copies of the documents. You know, every now and then you're going to walk in and your client's going to hand you something that you need 4 or 5 copies of. Figure out how to get them first. We have a printer in our attorney conference room. It may mean scanning a copy with your phone and printing 4 or 5 copies before you walk into the courtroom, because showing me a picture of something on your phone does not make it into the record the way that it would need to. I'm glad that your client just finished their last parenting class last night and they were handed their certificate, and they want to show it to you on your phone. If they show it to you on their phone, have them send it to you so that you can print it and make 5 copies of it so that you can hand a copy to every attorney on the case. I think a lot of what, as an attorney representing parents here, is helping to manage your client's expectations. I think it's a part of any successful law practice is helping your clients manage their expectations, not telling people what they want to hear, so that they part with their money faster. If you're handling divorces, you cannot make someone think that their spouse is going to have to sleep under a bridge because they were unfaithful to you. And that means that they're going to have supervised visitation with their children because they were unfaithful to you. You have to help your clients understand what's important, what's not important, and what's going to matter in a decision and what is not going to matter in a court decision, and helping them understand what to expect from litigation, as well as what they should expect to happen at a hearing. And I think that that is incredibly important, to help people understand that this is not the hearing that we come to decide if you ever get your kids back. or that your kids are going to go home with you that day. Like for a divorce, for them to understand that a contested divorce might take a couple of years. By the time petitions are pled, by the time everyone goes to mediation, by the time you exchange this discovery, a contentious divorce can take a couple of years. It doesn't have to, but sometimes that they do. But if you tell someone with a contested divorce that they can get divorced in 90 days, you're not helping them. Let's see what business cards, have them with you. Have an email address on your business cards. A fax number is a good idea to have on your business cards. Some people use e-faxes, but there are some attorneys that still fax, and there are some businesses that still fax. You probably need a fax number, and they're not incredibly expensive. And keeping a good calendar so that you don't double book yourself, overbook yourself. You can say no. When I say, is everyone available on March 28th? Sometimes the answer is no. You don't have to explain why. You do not have to explain that there's something more important than court. If the answer is no, I've got a calendar full of dates, and I would much rather know a date that you are actually available than for you to decide whether or not you think you can squeeze something into your calendar. I also think it's very important in practice to put everything on your calendar that is important to you, not just court hearings. If, like, for example, if my son had field day, it would go on my calendar and I would not schedule on top of it. I don't want to run into field day late or run out of field day before it's over or before I'm ready to leave. Sometimes I'm ready to leave before it's over. I got a lot of kids. So, but to hold things that are important to you in the calendar. And because most people keep an electronic calendar, even if you want to have a personal calendar and a professional calendar, keep them where you can see them both so that you do not schedule over things that are important to you. And saying I'm not available at the first, second, third, fourth, fifth date that I throw out there does not hurt my feelings. I do not take it personally that you have other places to be, and nor do you have to explain to me what they are. Let me see. One thing that you mentioned about your calendar, know that our dockets are incredibly busy. Right now, my first trial date available, I believe, is in June or July. So it is incredibly important that when you become aware that your case is not going to go, let us know. Please let us know so that we can make use of that time. I'm setting 2, sometimes 3 trials in the afternoon. And one of the reasons I can do that is because they don't go. Sometimes things happen that are unexpected. Sometimes, especially with COVID, there are people who thought they were going to be well enough to participate in trial. And even though we do try cases over Zoom, you have to be ready to try a case over Zoom. So if your client gets sick in the day before, you may not be able to try your case because your case may not be prepared to go forward over Zoom. But as soon as you become aware, like if there's someone who is hospitalized, if you have a client that is incarcerated and can't be transported, if the medical records aren't back, if there is something that puts you on notice that your trial can't go forward on the day that you expected, please let us know. And the way you let us know is by filing a motion for continuance and an order of continuance for us to sign, because when we can get those dates back to resolve other matters, it's incredibly valuable to us. I see that there's something in the chat. Oh, I see someone say Rachel King is fabulous, and I agree. So do you guys have any questions for us? Anybody?
Okay,
Oh,
Brittany, go ahead.
yes.
Hi. So I've actually been in your court, Judge McMillan, a couple of times. And a problem that we've run into, especially with COVID, that Judge Gunn has pulled up, is sometimes people get sick like the day of or the day before trial. When it comes to Zoom, because I know like your court is set up for it, how would that work with exhibits? Because I know you prefer physical exhibits to go into the file in case it ever goes to appeal.
Yeah. It's actually probably not in my local rules, but I probably need to add it. The code, when we had COVID protocol, I wrote a special rule. When we have a Zoom hearing, the exhibits are supposed to be shared between counsel. Anything you anticipate you may use as an exhibit. And they are numbered consecutively from 1 to 100, not plaintiffs 1 or defense 1, but 1 through 100. And then they are scanned and they are sent to everyone who will be there remotely, as well as to Miss King, so that your witness, you can tell them on that file that we sent you, pull up exhibit 4. And you know that she is looking at the same exhibit that you are on yours, and that you're projecting in the courtroom using the projector, or maybe from the laptop if you're working from your laptop, whatever else. We all are seeing the same thing. On those occasions where it's come up and I've actually had people stand with documents and hold them, here in front of the camera. What is this? Can you tell me what this is? It's not ideal, but it has worked. So, and that's what I mean. Check out your local rules. And I'll add, come into the courtroom a week earlier. I'm happy to show you once how the system works. And then I'm happy to try and point out that the autofocus button is here the next time. But the third time, I'm like, come on, guys, the autofocus button's on the front of the machine. I'm going to expect you to be ready to use it. And it's not as bad as it would be in a jury trial, where a jury is watching you and they don't have the perception that you're competent. But the better you handle the exhibits and the better you handle yourself in the courtroom, the more the opposing counsel and the more the opposing witnesses take you serious. And with a young attorney, that's sometimes difficult because you don't think anybody's taking you seriously because they don't know you, and you're going to outwork them. And then they're not going to take you, then they're not going to underestimate you anymore. Okay. Other questions?
And similarly at juvenile court, I have had, I tried one case over Zoom where when we were shut down because of a COVID protocol, we were not allowed to have anyone appear in person. And I've had some attorneys do an incredible job. And what they did was they made like envelopes of exhibits, so that when I started the trial, I was handed closed envelopes with about 8 exhibits in them. And if there was an objection, I wouldn't open it until I was to give them the opportunity to argue about whether or not something was relevant, or but we try to be incredibly flexible. There have been times that we've been trying things over Zoom and someone is emailing my courtroom clerk and she's printing it off. And if that's what we need to do to get it done, then that's what we do. So because of COVID, we've all had to become a whole lot more flexible. I have the same Zoom link that I use for every single hearing, because I think that it's easier that way. We have some magistrates that have a new Zoom link every day, and some of them have a separate Zoom link for every hearing. And that's just a matter of opinion as to how it should be handled. I figure if I got the same door every day, I can have the same Zoom link every day. I haven't had any security issues because I use a waiting room as well. All of our proceedings are closed at juvenile court, but I can look in the waiting room, I can see, and I'll let people in and for their hearing. I look to see who I can get. I was like, oh, I've already got so-and-so and so-and-so. Let's try to do this hearing. And I haven't had any security issues with it yet. And every now and then people say, well, hey, I just emailed this. And they say, okay, well, hold on a minute. I need to look at it first. And I'll wait. So you'll probably get a lot of patients when it comes down to COVID, preparing for a trial and preparing for a hearing during COVID. Will take some creativity, but we don't have a specific local rule for that. But sometimes we're just working more on just using what technology we can to try to make it happen effectively. It may be that it's like, okay, everybody's gonna send it to me, but I'm not gonna open them yet. Or they're gonna send it to my courtroom clerk and she's not gonna give it to me unless there's an agreement that it could come in. I've told people to talk amongst themselves about what is objectionable. And if there is something that is not objectionable, then our court case manager may print it and put it in the file. But if you send it to the court case manager and you say, I've checked, I've talked to the parties and everyone agrees that these can go in the file, or that these can be presented to the judge, you better be right. You better make sure you haven't forgotten an attorney, and that you haven't forgotten any of our pro se litigants, in determining what is going to be presented to the court. Anyone else have any questions?
I have a question. How would you suggest new lawyers approach judges and other people that are related to, the bench, the clerks and such, for advice or for questions? I know when I was first starting, I was petrified to ask questions of anybody. And I was in OP court and I had questions. And one of the attorneys there took me to the side and said, you can ask McMillan questions after your hearing and he'll be more than happy to help you. And that gave me some comfort. And I did, in fact, do that after my hearing. And he was more than willing to help me. But the fear of, am I going to look stupid? Or is this a question that nobody should be asking? Or like, are they going to look at you and think you should not practice law? What are you doing?
Okay.
How do you combat that?
All right. Does anybody in here, I know I saw Marsha earlier. She's Sarah Shepard. Anybody have met her or done any work with her, ever done anything with her? She hired me out of law school. I clerked for her my last semester after her associate at the time had a high risk pregnancy and couldn't be in the office. So she hired me to cover while her associate was on maternity leave, and then hired me after I found out I didn't have a job when I graduated. The only question you don't ask is a stupid question. And she would answer questions for me every day. And I'm sort of like that 2-year-old that you all have if you have kids. Why? And I learn things by turning them around and changing them just a little. So if this, how about that? If this, how about that? What if this is, and she was really patient. So I really, with my children and with anybody that I can be, absolutely would love to sit down about procedural things. Anybody know Tom Ramsey? He's a senior member of the Bar Houses firm. Anyway, Tom came and sat down with me. Greg, I got some things I need to run by you. And I get this problem. Here are my options. What do you think would be best to do in this case? Well, Tom, I think, as far as expediency this way, but in terms of what you really want to accomplish, you may want to consider going this way. But either way will work. It's just a matter of what fits your needs best. He goes, well, that's great. I guess I'll go back and finish up pleadings and file them in your, and I'm like, well, not in my court, you can't. So he had to go to Chancery Court and file it. But he fully intended, he didn't even think about the fact he was asking me before he intended to file it in my court, and I couldn't do it. So, my first question is, if I have a question, is it procedural or substantive? If it's procedural, I'll do my absolute best to answer it best I can. If it's substantive and it's not in my court, I'll do my best. And there are 4 judges that hear domestic relations cases. We all approach things differently. There's not any reason. And while I try really hard to be not consistent or formulaic, I tend to have an approach and a thing that I try to be at least, Steve Sharp calls it predictable. But I don't tend to say today is alphabet backwards day. I'm going to start with Z and work my way to A, and it's 180 degrees from the way I held on something yesterday. I'm going to look at the facts, apply the law, and the result may be different, but there's a reason why it's different for me. And if I don't articulate it, you may need to file a motion for more definite statement or additional findings of facts or conclusions of law. And it is absolutely my job to give those. And so when you're asking me to do my job, it's not going to be upsetting. Okay. And yeah, Rob and I are busy, but we just, it's fun. It's easier to answer questions. And if you don't have someone that you're practicing with or a good mentor, you need to find them. One thing I forgot to tell you about the court clerks, on an occasion, they can be known to give you an example of a pleading that will help you out. Hey guys, I'm trying to register this foreign decree from another state. What in the world am I supposed to do? Because there's 2 different provisions. There's the Foreign Judgment Act, which really doesn't do well in family law, and then there's the Family Law Acts, and they have different requirements, particularly if you're going to ask me to enforce it or modify it later. So they might, pardon me, they may have one that they can find a redacted version for you to let you look at as an example. It's helpful sometimes. I didn't think to talk about that, but they can do that for you.
And I would say that Knox County probably has one of the friendliest bars as far as your colleagues and who will help you. I think that the 2 places in this building where you can learn the most, well, I should say 3, but court watching. I welcome young attorneys to come court watch at juvenile court because our proceedings are closed. You have to, when you come in, I may say, oh, I say, who is that? Or who's coming in? Oh, remember, this is so-and-so. You told me I can come court watch. Oh, sure. Thank you. Welcome. So that you can just see what happens. I think it's incredibly educational. But then also the attorney conference room, when you're like, gosh, I have this situation, I don't know what to do. There's probably another attorney who has been in your shoes and can help give you some guidance, but also listen to them when they give you the guidance. Take the feedback. If they're like, whoa, that probably isn't going to go well, they're probably right. So lean on your colleagues in that way. But what Greg says is true. As far as procedural questions, you're like, how can I get these exhibits? What do I do? When do you want them? Is there someone I can give them to? But as far as substantive questions, a lot of times I'll have someone say, hey, I have a question. Can I do such and such? And they'll say, well, this is not your case. It'll be because it's the case that's being heard by one of the other magistrates. And first I have to say, wait a minute, is this my case? And it's like, well, no. Well, okay. Well, tell me what your scenario is, and I'll try to give some guidance, or well, how do you get that, or how do you this? But a lot of times there are attorneys who are who welcome the opportunity to share best practices, because good attorneys make better justice. You want everyone there to be in a position to put on evidence in a way that is succinct, that is effective. I want everyone to do a good job. And when everyone does a good job, then it's easier for me to get it right. And I want to get it right. And that happens when everyone knows how to put evidence on, and everyone understands what's important, and everyone understands what's not important, and can do so in a way that can help me make a good call. So, any other questions?
I had a question.
Sure.
So this is kind of more of a general question, but I guess what is something that you, thinking back to maybe your first year of practice, that you maybe struggled with, or just had a hard time with, or couldn't nail down, or couldn't figure out, or just gave you a lot of anxiety or stress, and maybe something that you see now in young attorneys that kind of makes you think back to that time?
Drafting pleadings, because you know, if it a custody case, you know, you have to put the UCCJEA declarations in. And I will tell you that I am old school. I expect to see the street address, the names of the people, and the months, years, weeks that they lived at each of those addresses and with whom they lived in. It doesn't do me any good to know over the last 5 years they lived in LA and Knoxville with their parents. You have to do it with that sort of detail. Making sure that you plead the appropriate standard. Are you asking for a change of residential parenting, which is a different standard than a change in the co-parenting time? And then that you have to plead that, you never want to show all your cards in a pleading. And as a trial judge, it doesn't really do nothing you guys say is evidence. So I'm going to ignore all the hearsay and all the attachments. I don't even look at them most of the time unless it's a TRO, and then only if I think I have to. If you haven't pled it and it's not in the affidavit signed by your client, I'm just not going to consider it. You have to make sure you've got the pieces in there. And then you want to make sure you haven't left anything out. And so, for example, this is the first request for injunctive relief. People leave that off. They forget to put the cost bond. They've copied it from another pleading. They've forgotten the client's name or a date or something is wrong. So you really have to, for me, it was pleading. And Sarah was excellent at, all right, I'm gonna quote, all right, Junior, this is what you did wrong. And I can still remember one of the first financial affidavits I did for her in an alimony case where my client showed he had an ability to pay. Our client showed he had an ability to pay. What's wrong with this affidavit? Nothing. I went through 2 years of checkbooks with him. I looked at everything. This is what it shows he has an ability to pay. And I can guarantee you that you can't run two households and what was running one. So figure out what's in here that, they're paying now, or figure out where it is and know what the purpose of your pleading is and match it to it. That was probably the hardest thing for me, and thing that's most frustrating, because I'll see clients come in, young lawyers come in for a default, or they file an ID divorce to come in for default and they haven't pled a fault-based ground yet. Then you have to go, and I usually let my wonderful assistant, Rachel King, call them and say, you guys are gonna have to amend and reserve this before you can default them, so that they're not, they're trying to take care of it beforehand when we get in to court. But that pleading is the hardest thing to get to know. And then the rules of evidence. The more you study on them, the more you call your evidence professor. Penny White to this day will take a phone call from me and answer a question for me about evidence. And there are lots of, hi Penny, start me back over. Exactly what's hearsay again? Because I've gotten it backwards again. I'm confused. And she'll run you through it. And it's critical. You can win your case by keeping something out. I hope I answered your question.
I think what I see the most is a lack of pleading or amending your pleadings, because a lot of times when you're dealing with child abuse and neglect, it's like shooting at a moving target. And there's also more information comes out after the emergency petition. So if you're going to make, so a lot of times people will come to court and ask for relief about something that they found out about a few weeks ago. And they just wait until we come to court and they're like, hey, we also wanted a restraining order against mom's boyfriend because the kid says blah, blah, blah. Well, when the kids say that, well, why didn't you plead it? Because you can't show up and ask for relief without filing a new motion. It's to remember to file in most situations. It's a motion for the Department of Children's Services. It's amending their pleadings to make new allegations because you want to start putting on proof about something that's not in the pleadings, and sometimes it flies. Sometimes attorneys don't object, but when they do, I can't let you put on proof about something that you haven't pled just because the other side knows about it, or just because it's in the best interest of the child for it to come out. That's the way we put people on notice of what we're doing there. So if something new has come up and you need to ask for relief based on it, please file a motion and put everyone on notice that you're asking for relief so that you can get it.
Hey, Becca, I'm going to also supplement my answer. Interrogatories and requests to produce and requests to admit. If you let your client answer those and you don't, interrogatories are horrible tools to get information, because all it is what the lawyer answers for their client. And if you're not writing the answers and you let your client answer it and you don't fix it or look at it and look at all the ways it can be used against you, it has to be factually correct. But it is not cute lawyering to avoid your client having been hit over the head by something. And it ties in with Robin. If an answer was correct when given, but then becomes incorrect, you have a duty to supplement it. Make sure you do. And with request to produce, make sure you're turning over your documents, because it's my least favorite thing in the world to do, to tell somebody you didn't turn it over in discovery. I'm not going to let you use it at trial. And that's what I think I have to do. Okay. Thank you.
Thank you.
Oh, you're welcome. Anyone else? Oh, come on, guys. You got 10 more minutes of free pot shots at two judicial officers who actually are being willing to talk and helpful if we can be.
I actually have a question about interrogatories and just discovery in general.
Mhm.
I feel like discovery can kind of be one of the most in my experience so far, which is very limited, it's like super contentious because nobody ever wants to do anything about it. But like, in both of your opinions, like how, I mean, obviously we always want to follow the rules, but sometimes following the rules to the letter can be super adversarial in a way. Like it can, would you just follow it to the letter, like file the ROGs, go to Rule 37, go for sanctions, file a 2605 follow-up? Like in your court, I hate to phrase it this way, but like how petty, like I'm afraid to use that term, but like it feels like it can kind of get there towards the end if somebody's really not complying with you. So just like how would you suggest we handle that?
First thing I do is read my local rules, and I think it's 22 or 24 that says that you have, when you go and see your lawyer and sign your complaint for divorce, you have to go back and then collect the last 2 years or as much are available records for all of your credit cards, bank statements, canceled checks, every financial interest, retirement, all that yourself. And the defendant, when they are served, has that duty. And then they are supposed to be made available upon a letter request. So I just send a letter. And I was infamous. Hey, here's all my clients' financial information. Please, for the love of everything that is holy and good in this world, do not send me the standard 30 interrogatories that you always send, because this is what we need. There are no children. We don't, it's a 10-year marriage. There really isn't anything big. They both are W-2 employees. Here's everything you could possibly want. And if there's something here my client hasn't told me about, please tell me what it is and I'll get it, or limit your discovery to that. So now that has always been my approach. You're not going to hide the ball. You're going to, if you're working, you will find what's in that discovery to be found that can be beneficial to you, or you're going to know, because you've reviewed your client stuff, what's in there that's harmful for you, and you will have worked your theory on how you're going to use it or defend against it. Never send something out you haven't gone over. Work. Now, I really do not like motions to compel. I have a local rule that says if you file a motion to compel and you sign it and send an order with it, it comes out to 13 days, because I say 10 days after the motion and order, I'll sign it, but you have to add 3 days because the rules of civil procedure. So 13 days, I'll sign that order and give them 20 days. And if they object, you have to object within that 10 days. I grant a hearing and we have an argument about why you shouldn't. There really is, the less unhappy I am about hearing those is the more focused and directed the discovery is. Because my first one's going to be, they claim it's not relevant. That's not a valid objection, but why isn't it relevant? All right, they're going to say X. Why is it relevant? And if you can't tell me in 5 words or less, then I'm inclined to think it really is relevant, or it really isn't relevant, depending on who's answering my question. And if it's a theory of the case and you don't want to tip your hand, Your Honor, like you see on the movies, Your Honor, I'm getting there. Okay, then, hi, what other questions am I going to need to look at to see how you're getting there before I understand where you're going? And we'll try to do that. But you do have to hold your feet on the fire. I don't know, hopefully none of you have ever been divorced and none of you will be. But when Robin says it takes a couple of years, it is, your life is on hold. You cannot think, you cannot work effectively. You can't parent effectively. You don't know what your money's going to be. You don't know where you're going to live. You don't know what your time with your children is going to be. You don't know if somebody's trying to move away. This service that I see is not being able to handle those cases for those clients and get them done as quickly as the clients would like to see them done, which is why I am so focused on being here and working. Let's go, because I think we owe it to those people whose lives, in a better word, are in crisis. So,
And in juvenile court, our rules are a little different. You don't have the same right to discovery. You have to start with informal discovery. So a lot of times that is an email, a letter, hey, can I see the TFAX records, which are the DCS records on a case? I normally tell people start there and exchange information informally and cooperatively, because and then when a lot of times what happens at juvenile court is someone sends someone formal discovery and they don't answer it because they know they don't have to. And then someone files a motion to compel. And then we're standing there and I say, hey, they don't have to answer this. Have you tried informal discovery yet? That is my question first. Well, what is it that you're asking them for that they won't give to you? And then often I'm turning and saying, why haven't you given them that? You know that they have a right to do this. Informal discovery is much less expensive to the parties. And it's much less expensive to the court, for everyone to just cooperate with informal discovery. They're going to have a right to it. In practice, like in divorce practice, if everyone just turns over, here are the financials, here they are. But I think and help your client understand they're gonna get to see your bank records. They're gonna get to see these things. And they say, well, why? Why do they? That I haven't been accused of anything. Say, well, it's called discovery because they want to see if they can discover something. So you don't have the right to tell them that they can't go looking, because they have a right to go looking because they married you, or because of this cause of action, or because they get to ask for it. So helping your clients understand that by contesting the discovery request will have the effect of prolonging the litigation. And like, you want to get divorced, don't you? Well, how about let's try giving them the bank records, because they're going to get them. And when people cooperate with discovery, formally, informally, it can help speed up litigation tremendously.
This isn't a question, but it's maybe just from advice, or my own advice from being in front of Gunn on a motion for contempt. But if you file a motion for contempt in front of Magistrate Gunn, don't forget to plead the part where it was willful, because it will get denied. I didn't totally do that myself. Didn't happen.
All right, anybody, any final questions from anybody before we get out of here? Just want to give everybody an opportunity. Okay, looks like we're all good. So everybody, thank you so much for being here, participating, engaging. Again, we extremely are grateful and appreciate the time the judges gave us. So we really appreciate you all being here as well. We're, as I said, going to put this on YouTube as well. So if you want to revert back to this for any advice or anything, feel free. We're going to share that with you, as well as get you the information about the March event when we get those details finalized. So Will and Magistrate Gunn, thank you both again so much for being with us.
I have one more.
Yeah,
one more
thing.
One last piece of advice. Be nice. Be nice to your colleagues, because your relationships with your clients in the matter will come and go. You are going to have to work with the attorney after your case is over. There'll be another time that you're going to need their patience. You're going to need their cooperation. You're going to need, so interact with your colleagues as though you're going to have to interact with them again, because you are. So sometimes you're going to have a client that says, oh, I want to contest this. They want a continuance. Don't give them a continuance. You explain to your client, they're going to get a continuance. Just whip out your calendar, work with your client, say to your client, hey, is there a better day of the week? Let me know what day is least disruptive to you, and help manage your client's expectation of unnecessary contention. So just be nice to your colleagues, and welcome to the bar. All right. Okay.
Perfect advice to end on. Be nice, everybody. Good. Thanks, everybody. Again, we hope you all have a great day. Okay.
Thank you.